I have had the advantage of reading in draft the judgment of my learned brother, the Honorable Musinga, President of the Court, for which I am grateful. My Lord President has undertaken a thorough account of the pleadings and the procedural history of the petitions that were before the High Court, as well as of the consolidated appeals, together with the submissions made by the parties. I will thus not rehash much of what he has so helpfully delved into, and will only refer to some of the arguments made before us where necessary for contextual or illustrative purposes only. The themes I consider it necessary to pronounce and give my particular opinion on in various degrees of depth and breadth are the following: basic structure doctrine, popular initiative, jurisdictional objections, legality of BBI process, public participation, presidential immunity, legal regulatory framework for constitutional amendment by popular initiative, IEBC quorum, voter registration, format of the referendum question, constituency apportionment and delimitation, and then a comment or two on the cross appeals and on costs. Now, on the basic structure doctrine, of all the holdings of the High Court, none have come under furious and sustained attack by the appellants, aggrieved thereby, as those relating to the basic structure doctrine. Hours of argument were added to the thousands of pages of scholarly and judicial authority marshaled by opposing parties in an attempt to cast as blatant and mitigated error, or for their defenders, pure genius, the first of the learned judges' dispositive pronouncements on the doctrine. Supplementing their written submissions with eloquent and passionate addresses, the aggrieved appellants were categorical that the Triple Declaration amounted to a rewriting of our Constitution and was wholly antithetical to settled jurisprudence, both local and regional, which to their mind wholly repudiates and rejects the applicability of this strange doctrine from foreign jurisdictions far removed from our particular circumstances. In his opening address, the learned Solicitor General, Mr. Kennedy Ogeto, took the view that the Constitution has no place for the doctrine and all its provisions are amendable in accordance with clearly set out procedures for various aspects of it. The Constitution has no eternity clauses, and Kenyans consciously avoided the basic structure by making no mention of it. They struck a proper balance between hyperamendability and rigidity by including Chapter 16, which entrenched provisions with special amendment procedures. That theme was taken up by Mr. Oraro, learned senior counsel, who posited that unamendable or eternity clauses cannot be recognized unless they are stated expressly in the Constitution. When pressed to point out where the doctrine was rejected, where exactly it was rejected in the report by the committee of experts, he responded, apparently without irony, that entrenchment was implicitly rejected. Answering another question about Colombia, he said that the Colombian case was an outlier and it is a divided country and we should not follow its example by acknowledging an implicit existence of a basic structure and an amendability in our own Constitution. He next made the submission that the case at bar was the first time the basic structure doctrine was applied in our jurisdiction. It had been adopted by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere, and it is inconceivable that we can introduce it in Kenya. Mr. Raro was emphatic that our constitution provides for its alteration, and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, Learned Counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to Counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yashpal Ghai and Jill Cottrell, Alicia Vernon, and James Gotv, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, Counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution lest the spirit of the Constitution should create a legal theology. Dr. Otienda Amolo, Senior Counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned Senior Counsel asserted that even then, the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned Senior Counsel Professor Githu Muigai still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists and brought by people who have standing. To entertain such grievances and make such orders at large leads to an erosion of the dignity and sanctity of the court, and then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyon, the Learned Counsel for the National Assembly, also urged rejection of the doctrine. But in the present case, he considered, as he had to, that 74 amendments proposed in the BBI bill were numerous. He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel, Mr. Job Wambulwa, was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiku's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga, Land Council Mr. Ndegwa Njiru was equally opposed to the doctrine, and returning, he made reference to the Kivuitu, Priscilla Ndululu Kivuitu and another versus the Attorney General, and he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subjected to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as Land Counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the BBI proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit, and that changes to that core structure can only be effected through the exercise of constituent power with four features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, Counsel made reference to John Locke's two treatises of government and Baron de Montesquieu's The Spirit of the Laws, to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which, though not spelled out in the constitutional text, are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution, and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the independence Constitution. He pointed out that Justice Ringera had acknowledged that, but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Rosnai, Counsel warned of the dangers of populist constitutionalism characterized by constitutional culture. He also referred to Dr. Mutaha Kangu's Constitutional Law of Kenya on Devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued elevate the political elite above the people. And finally, we would have to upset a settled theory of constitutional change. Referring to the case of Kesavananda, he indicated that our position is no less perilous than that faced the Indian courts, because we have 74 missiles that are trained at our constitution. To him, changing the constitution is not a normal state function, but an extraordinary authority. He pointed out that the power to amend is not authority to annihilate the constitution, which he warned could easily be abrogated by gradual amendments. He referred to the writings of Hans Kelsen to assert that the constitution is the Grun norm. It has to be accorded a more stable character. Thus, it is not enough for those intent on altering the constitution to just marshal the numbers, recalling that such formally compliant machinations have happened before. Land Council, Mr. Madenge, took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine because the Constitution has a core content and contains fundamental prior principles that are immutable in character. Making reply to all that, Mr. Nyamodi contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he conceded that Professor Rosnai is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya. And he seemed to suggest that it would be archaic and anachronistic to insist on a phenomenon from classical Greece where constituent power was exercised directly. Professor Muigai, Senior Counsel, in reply, labeled this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments, and specifically the case law and academic writings presented to support the rival positions, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties left me wondering whether we had facts and alternative facts. Well, I will refrain from drawing any inference that any of the learned counsel before us were out to mislead the court, at least at this point, and give it the most charitable interpretation that texts sometimes speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into a detailed to do a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and suppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mora, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for a more equitable share of resources, and they ensured that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting, the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to dry formalism in construction and obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that fealty to the constitutional text itself throws open the pathways of interpretation to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It would be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights, and to be both faithful and fearless in the cause is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. This is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I've mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further exposition. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that persuades, indeed binds me, is a purposive and holistic one, which repudiates the text as the alpha and omega on the divination of the meaning and intent of the Constitution. One needs only cast a glance at our history of constitutional jurisprudence to see the long shadow cast by a textualist obsession as exemplified in Republic versus Elman back in 1969. That approach, thankfully long interred, although every once in a while we hear its ghost clanging its chains, seeking a place at the interpretative table, declared that the Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Muthomi Ntiankolu's Landmarks from Elman to the Saitoti ruling, searching for a philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blessed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the Interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, the Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach, as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 2010 Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist, animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. The learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument, as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Mena Kiage and others way back in 2017, where, among other things, we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana vandima miri makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head, the extent and reality of presidential power, by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the reality that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions, the very next year by the Constitution Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of déjà vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobweze then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power were systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded, the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it is made. I have laid emphasis on the last part of the commentary because, to my mind, the people of Kenya were quite clear that they were not going to cede the Constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people, as creators of the Constitution, were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is, with great respect, quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of the people. It is not subject to the Constitution, which is but an emanation of it. This is the constituent power with which the people themselves, acting directly, can both make and replace a constitution. I've quoted Nabweze. The Njoya decision, which Ringera actually quotes Nabweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's ruminations on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The relevance of the constituent power to a discussion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he says, he gives an example of whether the Americans could decide and amend the first Constitution, the First Amendment, and replace it with an opposite fundamentally contradicting principle, such as establishing a state religion. Such a move would amount to a constitutional breakdown or revolution in the proper sense, and not a valid amendment of the Constitution. Professor Robert Albert, in an article called Constitutional Amendment and Dismemberment in the Yale University Law Journal of International Law, states that this Rawlsian view reflects the conventional understanding in the field of constitutional change. Either a constitution is amended consistently with the Constitution, or the alteration is so transformative that we cannot call it an amendment, and we must instead recognize that conceptually it creates a new constitution. Under that view, this would be the case even if the old constitution is not formally replaced with a new one. It can safely be argued that any amendment that alter the core aspects of a constitution, changing its character and ethos in a radical manner, is essentially changing its basic structure, and in all but word abrogates or dismembers the Constitution. The basic structure doctrine and the notion of constitutional dismemberment have the same effect of positing that such constitutional amendments are in fact unconstitutional. I've quoted the concurring opinion of Mr. Justice H.R. Khanna in Kesavananda. And I just want to mention that it's important to note that the Indian Constitution, just like ours, did not then and does not now contain unamendable provisions in its text. It lacks express limitations to its amendability. This is in contrast to some other jurisdictions in which the constitutions contain provisions prohibiting amendment of certain subjects, leading to the terminology, as Professor Raznai notes in his PhD thesis, the terminology of immutable, unalterable, irrevocable, perpetual or eternal, all of which he considers, and I readily agree with him, to be inaccurate. Why? Because they imply everlasting provisions, but they are neither eternal nor unchangeable. While they serve as a mechanism for limiting the amendment power, they do not and cannot limit the primary constituent power. Moreover, their content can also change through judicial interpretation. The Brazilian terminology, which refers to these provisions as Petraeus clauses, which I understand, that's me, which I understand to mean founded on rock. Petraeus clauses, to express their rigidity, is more accurate in that respect, since even rocks cannot withstand the volcanic outbursts of the primary constituent power. Therefore, in order to describe the legal situation more accurately, I refer to these provisions throughout this thesis as unamendable, as opposed to eternal or eternity clauses. The scholar notes that the technique of expressing prohibiting the amendment of certain state features, be they the form of government, separation of powers, or the like, spread like a fire in a thistle field, or, if you like, in the Gikomba clothes market, and was impelled in part to protect the Constitution by guarding against what he calls popular levity and legislative caprice. He then concluded that just as having a formal constitution virtually became a symbol of modernism following the American and French Revolution, so too nowadays having an unamendable provision is becoming a universal fashion. But importantly, he points out, which is germane to the analysis whether the learned judges were wrong in arriving at the conclusion they did, that the amendment power must be conceived as implicitly limited, even in the absence of any explicit limits. And it traces this back to the United States back at the dawn of the 19th century, refers to the works of John Calhoun in 1851, who wrote a book called Discourse on the Constitution and Government of the United States, and then also Thomas Cooley's Stories Commentaries in 1893. All these speak to the notion of intrinsic limitation to the amendment power, and it is not much different from the basic desire of Kenyans, I referred to earlier, that their constitution be altered only by the same means by which they made it. In Germany, the scholar Carl Schmitt was of the same view, that no revision of the constitution could provide for the destruction of its legitimacy. In short, the constitution does contain a core of implicitly unamendable principles which embody its identity. According to Rosenai, the argument in favor of implicit limitations on amendment powers did not remain in the realm of theory, but migrated from Germany to India in the 1960s, where, due to stormy political events, it was applied practically and most notably elaborated. I have indicated and traced the fact that that theory, doctrine, had an incremental fate in India. It was rejected in the case of Shankari Prasad versus India, and then it was again rejected in 1965 in the case of Singh versus Rajasthan. The first foothold of that doctrine was when a narrow majority of 6 versus 4 versus 5 of an expanded bench in Golaknath versus State of Punjab reversed those earlier holdings without invalidating the amendments in question. I need to mention here that that great break was contributed to by the writings of Dietrich Conrad, a German professor of Asian law, that had been placed before the court by one of the petitioner's lawyers, one M.K. Mambior, and I have indicated that this goes to show the value of research. When lawyers do good research, you get good results in the judgments. Now, the Golaknath decision, however, unleashed the wrath of a furious Prime Minister Indira Gandhi and signified the opening shot of the Great War over parliamentary versus judicial supremacy, and I've traced all that. When we came to Kesavananda, there was an extraordinary bench of 13 Supreme Court judges, and a narrow majority of 7-6 held that the amendment power does not include the power to alter the basic structure or framework of the Constitution so as to change its identity, and this is the kernel, the heart of the basic structure doctrine. Now, the majority faced reprisals from Gandhi. most notable being that her breaking with custom to appoint Justice Ray, the senior-most of the dissenting judges, as Chief Justice instead of the senior-most judge of the court, who happened to have been in the majority. Now, in Indira Nehru Gandhi versus Raj Naram, 5 judges unanimously confirmed the basic structure doctrine in 1975. Come down to Minerva Mills versus Union of India in 1980. Again, there was a unanimous holding that held that insofar as a certain section there removed all limitations on Parliament's amendment power, it conferred on it the power to destroy the Constitution's essential features or basic structure, and this was beyond the amendment power and thus void. Now, contrary submissions were made before us, the basic structure doctrine, from my reading of the cases subsequent to Kesavananda, demonstrates an ascendant trajectory to the point that it is firmly settled as a doctrine in India. The split majorities of its inception gave way to consistent unanimous decisions of the Supreme Court, so that the so-called compelling case by R. Dhawan, said to be a respected advocate and leading Indian scholar, that Kesavananda ought to be set aside, would seem to have no solid foundation in my respectful view. It has stood for more than 50 years, or about almost 50 years now. When I turn to other cases, in Malaysia, for example, I have quoted 2 cases from Malaysia which seem to show that the doctrine was more accepted than repudiated. I have also taken note that other Asian countries such as Bangladesh and Pakistan have embraced and fully affirmed the basic structure doctrine. I've quoted some cases there. And citing various cases from far away Central and South America, specifically Argentina, Belize, and Colombia and Peru, Rosnai comes to the conclusion that the basic structure doctrine has migrated far and wide across the globe. Some of the arguments that were made before us here were made in Belize, and the Supreme Court, in the case of British Caribbean, had this to say. They referred to the Indian basic structure and then said, though the Constitution of India is different in several respects from our Constitution, both constitutions have basic structures, features such as judiciary, rule of law, fundamental rights, and separation of powers. As I have stated before in this judgment, constitutional borrowing, cross-pollination, and interpenetration of notions is perfectly legitimate and is the proper way to develop the law, while ensuring that whatever is borrowed is relevant, useful, and fitted to suit our particular circumstances. I need only add that the legal scholars have recognized and encouraged constitutional borrowing by courts for persuasive purposes, and there are all manner of articles. Can constitutional borrowing be justified? In the University of Pennsylvania Journal of Constitutional Law, and then constitutional borrowing in the Michigan Law Review. I note with a measure of bemusement that while castigating the learned judges for relying on foreign jurisprudence, the aggrieved appellants have laid before us numerous decisions of foreign courts. I was at first minded, I have mentioned some of the things that were quite off in the manner in which the submissions were made. We were told that cases said one thing when in actual fact they said something else. I'll give an example. In one of the submissions, it was said that in Uganda, the Supreme Court, in the case of Paul Semogerere and others, equally dismissed the Kesavananda doctrine. And then they quote a passage that I think was quoted by one of my colleagues this morning about those who make the Constitution know what's good for them, etc., etc. And then, but now, this is what I say. Now, after reading, from a reading of that passage quoted by counsel, the impression is that all those words were by Mr. Justice Tesekoko of Uganda. But in truth, only the last paragraph contains his words. Now, having read the Semogerere judgment myself, which was usefully, if ironically, supplied by counsel in volume 8, I cannot but respectfully conclude that the case does not at all advance the appellant's particular argument or case. First of all, it turns out that the bulk of the excerpt attributed to Judge Teseko Tesekoko are not his words. They are actually words apparently found in a Kesavananda dissent, which the judge quotes, not directly from the judgment, but as said to be quoted in a Singaporean case. The judge himself puts it thus at page 8 of his judgment. He said, no copy of the judgment of Kesavananda case was availed to us. I have not been able to lay my hands on the full judgment, but passages of it are quoted in the Singaporean case of Sesolung. Now, with great respect, I cannot see how it is possible for Semogerere to have dismissed Kesavananda, as we are urged, when the judges deciding it had not even engaged with the doctrine and had not even read the judgment. In fact, nowhere in Semogerere is there a whiff of rejection of the basic structure doctrine, which is the heart and essence of Kesavananda. To the contrary, Tesekoko J indicated that in his considered opinion, Kesavananda case was misunderstood and therefore misapplied to the petition that was before the Constitutional Court. And then he talks about what he thinks Kesavananda, which he didn't read, was about. Now, I did not say anything on the judge's understanding of the issue in Kesavananda, which I, unlike he, have read in full. But it should be obvious that given the infirmities I have pointed out, Semogerere, as presented before us, cannot be a basis for the contention that the basic structure doctrine was rejected in Uganda on that occasion. The same also goes for the case of Male Mabirizi and others versus the Attorney General of Uganda, where it seems to say, the judge said that the basic structure doctrine is still at a nascent stage of development. This is a 2018 decision, but from what I've said, the basic structure is not nascent, it's not new, it has actually grown quite old. Now, having undertaken so detailed an account and analysis of the Indian experience with the basic structure doctrine and its migration across the globe, I have no difficulty discounting those conclusions as untenable. I would also reject the decision cited to us of the Honorable Attorney General of Tanzania versus Christopher Mtilika, because there the court said, the Court of Appeal of Tanzania, it said that the courts must eschew a loosening of judicial discipline in interpreting the explicit provisions of the Constitution. And they went on to say that a tightening of judicial scrutiny would be necessary. Now, I think that is the very antithesis of what our Constitution requires of our courts. I cannot accept as a correct reading of the Constitution, less still a persuasive one, for me to follow the conclusion reached there that everything is amendable once the procedure for amendment is followed and that the basic structure doctrine does not apply. The conclusion I have arrived at, out of my forays into the jurisprudence and learning I have referred to, and much more besides, is that the basic structure doctrine is legitimate and sound. I would think it's strange that anyone would doubt the existence of a basic fundamental essential core, being the pillar upon which the Constitution stands, and from which its character, ethos, and identity flows. There is a certain undeniable simplicity to the notion. I thought of it as a house. Any and every house, be it simple, complex, and elaborate, must have structure with its bare essentials. Even as some houses have fewer items than others, going into their basic structure than others, so would different constitutions differ in complexity. I was pleasantly surprised to see that Joseph Raz, in a book called Between Authority and Interpretation, uses the analogy of a house to differentiate between minor changes to the Constitution, like redecorating a house, and major ones that alter its character. Rosner refers to that very analogy of a house. I will not say much more on what he says. I cite the passage, I've cited a passage at length to signify my full agreement with the learned judges that the amendments proposed by the BBI initiative and bill were so far-reaching in character, scope, and content as to shake the foundation and alter the identity and character of the Constitution. They were effectively dismembering the Constitution, blasting so huge a hole in it as to pulverize its foundations and essentially create a new constitutional order. To do so would not be to amend the existing Constitution, and therefore there was need to resort to and summon the primary constituent power. The mere invitation of the people to vote on the radical transformative proposals at a referendum was not an effective summons of the correct authority, because the people acting on the amendment plane constitute the secondary constituent power only and are limited to amendment. They are in no position, while acting in that capacity and space, to endorse and effect a constitutional replacement. This latter they can only do in primary constituent mode. Now, Rosnai, I believe, asserts crucially that the amendment power is a constituted power even if exercised by the people. Moreover, no constituted power should be entitled to abolish the democratic system. To my mind, that is the cognitive posture that we should adopt in answering the question whether the notion of limitations to the amendment power discussed by so many courts loses any of its logical force by the fact that the amendments proposed in the case at bar and contemplated by Article 255 and 57 of the Constitution require approval by the people in a referendum. The conclusion appears to me inescapable that as long as what is contemplated is an amendment, it will ipso facto be limited. The limitation in this case stems from the fact that certain aspects of the proposed amendments unquestionably go to the essential core and fundamental fabric of the Constitution, thereby purporting to alter irredeemably its character and identity. Such radical alterations are not amendments in the real sense of the word, for there has to be a limitation to what amendments can achieve. And I would think that dismemberment is dismemberment, whether effected through surgical amputation or through rough mutilation. It matters not whether you carve Caesar as a dish fit for the gods or hew him as a carcass fit for hounds. The cats are mortal either way. I have said enough, perhaps more than enough, to show that I do not think a sufficiently compelling case has been made to warrant our interference with the conclusion that the learned judges reached with regard to the basic structure doctrine and its applicability in Kenya. I have gone back to what Lenaola J. had to say in the Commission for Implementation of the Constitution, was National Assembly. I am fully in concord with the reasoning. I'm so fully in concord with the reasoning of Lenaola J. that I will not add a single jot or tittle to his reasoning. Having come to the conclusion that the basic structure doctrine is applicable, the conclusion is also inescapable that the amendment power set out in Article 255 to 257 of the Constitution is limited and that the basic structure can only be amended through the constituent power. That constituent power can only be properly summoned and exercised in accordance with the four-sequence process of civic education, public participation and collection of views, constituent assembly debate, preceding a referendum. And this accords with the holding in Njoya. I would hold without hesitation that a referendum cannot be effective as contemplated by the constituent power unless the initial three steps have been involved and engaged in real and substantive as opposed to a ritualist and minimalist manner akin to a mere token ticking of boxes. Ringera J. said, all in all, the limitation of Parliament's power was a very wise ordination by the framers of the Constitution, which is worthy of eternal preservation. I think, with respect, that the amendments to the Constitution contemplated and proposed by the BBI Amendment Bill have the potential to alter by one fell swoop the fundamental pillars that define and undergird our Constitution. They are truly no less than a ballistic attack on our Constitution's foundations, including separation of powers, independence of the judiciary, and Chapter 15 commissions and independent offices, not to mention supremacy of the Constitution, sovereignty of the people, and the national values and principles of governance. I accept that this is not exhaustive and should be dealt with on a case-by-case basis. Ringera J. indicated that we have been down this road before, but without judicial challenge. I surmise that a cowed populace probably did not have the courage to seek redress, nor was the judiciary back then particularly famous for the defense of the Constitution. For the superior courts of this country at this time, there is no luxury of indifference or neutrality. Where in former times no challenge to the manifest alteration of the Constitution's basic structure was made, thus sparing the court the burden of decision, we are today summoned to the valley of decision. Civic-minded Constitution-defending citizens have raised alarm at the threatened dismemberment of the 2010 Constitution. The High Court has, with crystal clarity of reasoning and felicity of dictum, raised a barricade against such a scheme. And it is upon these courts to either raise the bulwarks of defense even higher and place around the Constitution a wall high and impregnable against such machinations, or, as we are urged by the appellants, we disable the brakes, uproot the ramparts, and usher in an open season for the systematic and unbridled dismemberment of the Constitution. To me, there's only one path that commends itself consistently with conscience and fealty to the constitutional command. I must defend it and keep its fortifications firm and effective. I must stand up for the Constitution, heeding the words of the hymn, where duty calls or danger, be never wanting there. I have referred to the aspect of illiberal democracy and its growth, and I've talked about Professor Rosalind Dixon and David Landard. The point they point out that the constitutional amendments or basic structure doctrine, though at times attacked as being anti-majoritarian and making courts too powerful, is in fact a useful tool to help preserve so-called fragile democracies against the democratic erosion that is inherent in abusive constitutionalism. Beyond textually stated eternity clauses, they point out that many scholars and courts have argued that the doctrine can be defended. Now, however, given I am persuaded that the referendum requirement is at best an exercise of the people's secondary constituted power, or, as argued by some, an aspect of the constitutive power contemplated by the Constitution itself as part of its amendment procedure, I am better persuaded by the unconstitutional constitutional amendment / basic structure doctrine. I am justified by this view, by my appreciation that even referendum procedure can be made of no effect by a deficit of prior civic education and public participation. Indeed, someone has said that for populists, a referendum isn't meant to start an open-ended process of deliberation among actual citizens to generate a range of well-considered popular judgment. Rather, the referendum serves to verify what the populist leader has already discerned to be the genuine popular interest as a matter of identity. An effective bulwark against abusive constitutionalism, therefore, seems to me to be on the authorities, one that entails more as opposed to less people involvement. I think, therefore, that there is nothing anti-majoritarian or doctrinally abhorrent about the four-step process the learned judges held to be indispensable for effectuation of amendments of the kind proposed by BBI. It has to be recalled that the restriction to amendment need not be in express text. It is generally accepted that in keeping with the interpretive posture addressed earlier in this judgment and on a proper understanding of the basic structure doctrine, the limitation can be implicit. Therefore, it is the people themselves who preferred rigidity over flexibility. They were bothered by hyper-amendability, and for me, the numerous amendments proposed are no less offensive because they are presented in one bill at once and not through staggered installments over time. Justice Chandrachund in Casavananda stated that the basic structures theme song is amend as you may, even the solemn document which the founding fathers have committed to your care. For you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity. In short, it is undeniable that by using the basic structure doctrine, the judiciary does play an important role against democratic erosion, and I would, without hesitation, affirm the learned judges on the basic structure. My voice is running out, so I will just make a few comments on the other issues. Popular initiative. I have held that in the amendment scheme of the Constitution, it is clear beyond peradventure that as far as the characterization of the amendments to the Constitution go, there is a binary reality with two distinct, dichotomous, and disjunctive initiatives, the parliamentary one or the popular one, each providing a distinctive methodology or procedure. And what appears clear from the Kenyan experience is that the popular initiative was introduced as a response to citizens' frustrations with Parliament, to whom the law-making power is delegated. It was not always acting in a citizen-centric manner, and often acted in a manner quite inimical to the interests of the public. The popular initiative is therefore a mechanism for the people to exercise direct authority in the amendment of the Constitution. It is a power reserved to them as the sovereign to do that which Parliament may have defaulted in doing. This is consistent with Article 1, Sub-Article 2, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Admittedly, this form of active, direct, and deliberate democracy is quite new in the African experience, but has been around for quite a while in other parts of the world. Referred to variously as the constitutional initiative, mainly in America, or citizens' initiative in Europe, it has certain discernible characteristics which are pointed out. Now, one of the things to note is that in an article by Maya Setale and Theo Schiller, editors, Citizens' Initiatives in Europe, Procedures and Consequences of Agenda Setting, the author draws a valid and useful distinction between compulsory referendums, which are for constitutional changes proposed by the government or the Parliament, and the popular initiative, which allows for any other group outside of the Parliament to put a proposal on the table. By the term popular or citizens' initiative, we refer to procedures that allow citizens to bring new issues to the political agenda through collective action, that is, through collecting a certain number of signatures in support of a policy proposal. The role of these citizens' organizations, social movements, civil society organizations, etc., they are the ones who lead the citizens. The role of these organizations outside of formal representation through Parliament is the answer to the political marginalization of the citizens, famously expressed by Jean-Jacques Rousseau in the Social Contract this way, and which might have universal application. He said, the English people, and you could put any other people there, the English people think that they are free, but in this belief they are profoundly wrong. They are free only when electing members of Parliament. Once the election has been completed, they revert to a condition of slavery. They are nothing. End of quote. It includes, in the perspective, other optional plebiscites which are identified as presidential, governmental, or parliamentary initiatives. And these are contradistinguished from the direct democratic perspective that trusts in the people to initiate the direct decision-making process. In this range, we have the popular initiative, the popular referendum initiative. From my reading of the literature on these subjects, I am fully fortified in my view, which coincides with that of the learned judges, that a popular initiative is a citizen-conceived, citizen-initiated, and citizen-driven process. And these are the ordinary mwananchi. If the initiative is born of presidential fiat, no matter how well-intentioned, it ceases to be a popular initiative and must be recognized and named a state or presidential initiative. Now, in answer to the question whether what happens when the president has a parliament that doesn't listen to him, I do not doubt that the president, with his wide array of powers and influence, could have used the parliamentary initiative through his party and others with which he works, or could work in a coalition of the willing to bring about the changes to the constitution that he seeks. The president's role in the conception and initiation of the Building Bridges initiative is writ large, and with it, the panoply of power and prestige of his office. First was the handshake, then the BBI Gazette, which was appointed by, task force was appointed by Gazette, which is an official government publication. The task force prepared a report, which it presented to the president as president and commander-in-chief. Moreover, the president again appointed the steering committee on the implementation of the BBI report by way of a special issue of the Kenya Gazette. Their report was presented to the president at a state lodge. That everything about the process bore the imprimatur of state involvement. It was a presidential government project, and this was wholly antithetical to the popular initiative. Like Machiavelli's prince, the president's conduct is different from that of ordinary citizens. In acknowledging this plain and in spirit of fact, one does not thereby curtail the president's enjoyment. One might even say deployment of his personal or political rights. All it means is that the space upon which he elected to exercise his rights is reserved for ordinary citizens, the common populace of the Republic of Kenya, and it is not open to the president. It is out of bounds to him. The question is, first of all, hypothetical, but to my mind, the president does not shoulder any obligation to initiate constitutional changes. He takes office under and in accordance with the Constitution, and his duty is to obey and defend it in keeping with the oath of allegiance, not to change it. It follows from my reasoning that I agree with the learned judges that insofar as the president took certain actions at the inception of the BBI process, including appointing the task force and later the steering committee by gazette notices in his capacity as President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the popular initiative path, a preserve of the ordinary citizen, was not available to him for initiating any amendments to the Constitution. I would dismiss the grounds of appeal challenging that finding. Next, jurisdictional objections. I do not think there was any merit in the claim that the matters were either sub judice or were res judicata, and I've dealt with that wholly. I agree with the judges on that point. Let me rush quickly to the legality of the BBI process. I've said things there that initially that already give an answer to this. But given there was never indication, I should start here. A number of critical facts stand out in crystal clarity from that gazette notice which appointed the steering committee. Regarding the steering committee, which taken singly, together, or wholly, go to declare that it was a presidential creation and a government project tasked with inter alia proposing constitutional changes for the implementation of the report of that very team in its previous emanation as the BBI Advisory Committee, and the facts are there, I've stated them. Given there was never any indication that citizens of this country had, in and by themselves, conceived of the idea to change the Constitution in a particular manner as the genesis of this process, but appear only to have been roped in to respond to what had already been given life and motion by the president when he appointed the task force, the process that was being undertaken was not a popular initiative. And it matters not that it may eventually have gained the liking or admiration of many people. That sense of popular is not what is meant by the Constitution, which uses popular in the sense of pertaining to the general public or ordinary citizens. The BBI Steering Committee, by inception, composition, and operationalization, was a government presidential project. The members were not ordinary citizens who came together coalescing around an idea that the Constitution needed to be changed in particular respects. Instead, these were prominent personalities joined together by a presidential fiat. They had no mind or idea of their own to initiate, but were instead tasked to identify constitutional, among other changes. It was not open to them to purport to craft constitutional changes and even come up with the BBI Constitutional Amendment Bill purportedly as a people's initiative. They were, without a doubt, a government project, and it was impermissible and untenable for them to seek to camouflage their process as a popular initiative, which it was not. They were essentially seeking to hijack the People's Initiative route under Article 257 of the Constitution, and this was clearly intolerable and indefensible. It was also contrary to the letter and intent of the Constitution. That, I think, provides the answer to what I had to say about that aspect. Yes. I think I am dealing with... yes, public participation is the next point. And under public participation, I have indicated the Constitution itself, a product of super participation on the part of the people of Kenya, recognizes participation of the people as one of the national values and principles of governance. It is listed in Article 2A alongside patriotism, national unity, sharing and devolution of power, the rule of law and democracy. I have no hesitation holding that participation of the people is what gives meaning to and serves as the guarantor to the tangible realization of the other values and principles of governance. It is what gives substance and brings to life as a present reality the idea that democracy is a system of government of the people, by the people, for the people, as famously put by US President Abraham Lincoln in his Gettysburg Address on November 19, 1863, which he hoped shall not perish from the earth. Participation by the people is in the matters that concern them, when done in a deliberate, substantive manner, acknowledges the sovereignty of the people and treats them as master of their own destiny. Their autonomy, individually and as a collective, is mainstreamed, even as the paternalistic state and its officers that so easily assume the position of ex-cathedra directives recede to a facilitative as opposed to a command position. Once the people are involved in policy formulation, legislation, and in the greatest, most solemn role of constitutional amendment, they get to own both the process and the product. They are no longer pawns on a political chessboard. They are not mere voting machines at the beck and call of political operatives. They are not commodities for sale to the highest bidder. They retain ultimate control over government and are not at the control of government. The Constitution says so, and it is the duty of those who enforce or interpret the Constitution to give real meaning to the principle in its widest and fullest manifestation. Now, I have said many more things about public participation, but long and short, yes, there's an aspect. I agree with the judges generally when they talk about public participation, but whereas the above reasoning is perfectly in line with the public participation, with what it would require in a matter of such moment as constitutional amendment, I must express my unease, brought out quite poignantly by Mr. Karori in his address to us, that it would be to place an onerous and well-nigh impossible burden on promoters of a constitutional amendment by popular initiative to expect them to go the whole hog, captured in the above excerpt, including translating it into all the languages, having it in Braille, etc., and sending it all over the country. That to ask them to do that before they collect the signatures might be a bit too onerous. It seems to me, with respect, that the requirement stated by the judges must be present before or at the time of the voters finally make their decision on the proposed amendment at the referendum, failing which the mandatory requirements for public participation will not have been met, with fatal consequences to the proposed amendment. I am of the view, however, that the elements of public participation stated must perforce be understood to form a spectrum or a continuum which is incremental in character. It would be way too expensive and onerous to expect that citizens seeking to introduce amendments, be it by way of a general suggestion or a formulated bill, must engage and involve the voters generally, by which the learned judges must be understood to mean the national vote pool, from whom the promoters would be seeking the 1 million supporters, to the broad and extensive elements of public participation enumerated by the learned judges. I think that the duty they bear at that point of signature collection is one of sensitization with candor and disclosure, as opposed to one of full broadcast by all means, in all languages, to all voters of the full particulars of the exact amendments by way of the amendment. It is enough that a voter should know what is sought to be introduced by amendment in sufficient detail to be able to make a decision whether it is an initiative he would support by appending his signature at that stage or not. To that extent only, would I respectfully fault and reverse the learned judges while leaving intact their reasoning and holding on public participation with regard to the totality of the process up to the referendum. Of course, it has been argued that why worry about public participation? The way you look at everything else, the way it is set out, there will be enough moments for public participation, and perhaps the judges acted too fast and too soon. And I think, with respect, that whereas on paper the argument does sound attractive, the reality on the ground, as became apparent during the hearing of the appeal, is that there was a measure of cynical disregard for the very opportunities and timelines intended to facilitate public participation. Even for the signature collection, for instance, it turns out that the IBC apparently published the list of the persons listed as supporters of the initiative to facilitate confirmation by the people that the list was accurate, thereby seeming to involve them. This was in reality a mere show, devoid of substance, however, for the reason that the list was published by the IBC on the IBC website only, and then the public were informed of the fact on Thursday, 21st January, and were required to have notified IBC of any complaint by the following Monday, with a weekend in between. It means that the people of Kenya were given but 2 days to access information available only on a single platform. Under those circumstances, it sounds rather strange for IBC to point at the apparent absence of complaint as demonstrative of accuracy or satisfaction. It could well have been due to absence or, at the very least, insufficiency of access. Another glaring and troubling example that was cited in argument before us was the lightning speed at which the amendment bill was rushed and passed through county assemblies. The Constitution deliberately indicates that they are to consider the bill within 90 days. And it is argued that properly so, that the period is intended to facilitate public participation, which I take to take the form, at the minimum, of publication of the bill within the county, followed by consultation, receipt of memoranda, debate in public forums organized for the purpose, and on other platforms so as to involve the people and obtain their instructions, thereby establishing whether or not to support or approve the bill. What was witnessed in most counties, however, was a farcical disregard for the people and the Constitution. Many county assemblies made absolutely no pretense to involve the citizens resident in their counties, spurred on no doubt by certain incentives beneficial to themselves, the most notorious of which was their demand for some 2 million shillings car grant, which was quickly granted by government. The usually slow and tight-fisted Salaries and Remuneration Commission, despite well-known fiscal challenges and a raging global pandemic, somehow managed to prioritize, approve, and find funding for that particular incentive for MCAs, which seems to have attained the status of a national emergency. What in the end seems to have happened in county assemblies was a mad rush to demonstrate personal gratitude and party loyalty, with some passing the bill in but a couple of days. The people did not matter. They might as well not have existed. And no superior court in this country, properly directing itself on public participation, would in conscience accept as permissible such violation and negation of the constitutional scheme and command to put the people first and center in public affairs, of which amendments to the Constitution is definitely the most solemn. I would affirm as correct the holding of the learned judges that county assemblies are under a duty to approve or reject a constitutional amendment bill in a popular initiative whole without amendment, so as to maintain and preserve its content and character inviolate as a popular initiative. It is also the more reason why they are under a clear duty to be scrupulously and faithfully discharged, to involve the people so as to discern which way they should vote on the amendment bill. On presidential immunity, all I will say, first of all, is that there was an issue that His Excellency the President, Uhuru Muigai Kenyatta himself, it would have been neater. It would have been neater if the President himself joined the proceedings and raised objection to his having been sued in his personal capacity. But he was not. Now, the issue that arises is that he appears not to have been served, and I might as well state at this point that the learned judges ought, at the very minimum, to have first satisfied themselves that service had been effected on him by the petitioner before proceeding to hear and determine the matter, and to even make pronouncements against him. This is a fundamental and basic tenet of natural justice, and the rules as to service or process are quite explicit as to what is required to have been done. I therefore agree with Mr. Gatonyel, Senior Counsel, that any adverse orders made against the President in his personal capacity would be open to setting aside ex debito justitiae. That does not mean, however, that the learned judge's finding on the extent of the President's immunity from civil suit is also affected, because this is a matter of constitutional law, not personal to the sitting President. And I have quoted Article 143(2), and the argument was that the President should be impeached in case of things that happen outside of his. In fact, the argument was that he enjoys absolute immunity. Now, as an impeachment can be challenged in courts, it was counsel's view that it was putting the cart before the horse for the courts to entertain suits against the President in his personal capacity before he gets impeached. When seeking clarity, I asked counsel the hypothetical question of what my neighbor out in the village of Karaos, Kesogon, Trans Nzoia County would do were I the President and my dog beat his child. It was counsel's confounding answer that the only recourse open to my neighbor was to seek my impeachment. He cannot be right, not least because there is nothing presidential about such a canine indiscretion that would only invite tortious liability. Counsel drew the attention of the court to Article 165 of the Constitution that gives judges immunity, and in particular the case of Bellevue Development Company and Francis Gikonya and 7 others. I am familiar with it. I wrote a judgment in it. But the position I take, is that the protection that is given to the president has to be purely functional, related to his office, and does not extend to any matters that are done outside or in violation of the Constitution. In fact, from my analysis, it is possible to state the law on presidential immunity to be this: the president is immune from criminal prosecution and from civil suit for any act or omission in exercise of his powers under the Constitution in Kenya's tenure. That the president had under the old Constitution, where it was absolute. And I would say that absolute immunity, which existed under Section 14 of the retired Constitution, appears to me to be an anachronism and an oxymoron in the context of a constitutional democracy such as we are, that upholds as part of its national values and principles of governance the rule of law, good governance, integrity, and accountability. Those values and principles, alongside constitutionalism, which denotes limited government, denotes limited government, must mean that the office of president, being a creature of the Constitution, is and must be subordinate to the Constitution, and its holder must be held to account for his acts and omissions. The president is not above the Constitution or the law, and is not a law unto himself or herself. In recognition of that preeminence and importance of the office of the president, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143.2, and the fact that Article 143.4 expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, that each act must be shown strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president, Richard Nixon, was held to have was from damages liability predicated on his official duties, official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue here, coming out of petition number 426 of 2020, are those acts which are said to have been committed by the president outside his constitutional powers and in fact in contravention of the Constitution. And the learned judges held, and I would respectfully affirm, that the president is not immune from suit for that. I only need to add that the days of an accountable presidency are long gone and are of only historical significance as a lesson and a warning to the citizens of the country to be vigilant and to demand accountability from the person to whom they entrust the responsibility of leadership. Experience, as recorded in many cases, both local and comparative, shows that in a democracy, no office is immune from accountability to the law as administered by the courts. I hold that the appeal challenging the learned judges holding on presidential immunity from suit in personal capacity should fail. Regarding the legal regulatory framework for constitutional amendments by popular initiative, I have mentioned some of the arguments that were made, and I would say that I think it's a matter too plain for argument that the country does need a referendum act, and there is none at present. The learned judges were informed that there was a proposed referendum bill somewhere in the legislative pipeline, but there seems to be uncertainty as to its eventual fate. So it's interesting that, and odd that the Attorney General, who should have been at the forefront in seeing the legislation is in place, the IBC, which needs it for proper conduct of referenda, and the BBI Secretariat, which needs it to be guided by it if it were to pull through the proposed amendments, all seem to speak the same strange language, that the gaping lacuna is of no significance or moment. With great respect, I do not find such a stance by critical players in a national exercise to be of great importance of great importance to be particularly helpful. And I do hold the view that candor in public affairs, including in litigation, is a virtue to be embraced. It cannot be right for parties to propound in court positions they know to be so plainly untenable, and to do so without batting an eyelid. That this country needs a referendum act is an urgent matter and should have been addressed years ago. Now, the Attorney General went on to assert that all motions involving the furtherance of popular initiative are an exercise of citizens' political rights as enshrined in Article 38, but they should not be limited by a flimsy excuse of lack of regulations, administrative procedures, or statutory prescriptions not expressly provided for under the Constitution or legislation. That's what the argument was. Whereas the Attorney General is quite right that the enjoyment of fundamental rights cannot be conditioned upon the enactment and promulgation of any statutory rules or regulations, with the absurd result adverted to where rights are held at ransom by official neglect, I do not think that the learned judge's decision was to that effect. I fear the Honorable Attorney General appears to have misapprehended the reasoning of the learned judges, which was quite the opposite of the meaning he ascribes to them. In fact, judges at paragraph 6 or 3 of their judgment say that even if there is no referendum act, it is still possible to under proper with proper adherence to the Constitution, to go right ahead and hold a referendum. I think, with respect, that given the uncertainties, ambiguities, and penumbras that are apparent in the manner in which one is to go about initiating, collecting signatures, forwarding, debating, involving the public, campaigning, and voting on a popular initiative for the amendment of the Constitution together with the necessary timelines, this area is in a wholly unsatisfactory state and needs clarity by way of both national referendum law and probably rules and regulations specific to the popular initiative. It is disingenuous for it to be argued otherwise unless uncertainty in law should somehow have attained a utility I myself cannot discern and a status of a virtue. I am firmly persuaded that a referendum in the context of proposed constitutional amendments by popular initiative must be governed by a specific, properly thought out legislation. It cannot be left to the Elections Act, which seems to contain a part of the referendum in some kind of by the way or afterthought, regard having heard to the fact that referendums are not elections and they are no less important than elections. I would go as far as to state that whereas the provisions on the referendum in the Elections Act may suffice to settle questions of various types and descriptions in an ordinary referendum, they are not sufficient in detail and clarity and were not formulated to meet the full requirements of Article 257. I should think, with respect, that it speaks to a national malaise of inattention to duty, a satisfaction with dilatoriness, and being reactive instead of proactive on the part of officialdom, that the referendum law has never been passed, notwithstanding that some 2 years ago, Justice Nyamweya had spoken, Nyamweya J, as she then was, had spoken of its glaring need in the case of Republic versus County Assembly of Kirinyaga, ex parte Kenda Muriuki, and another. Now, in resolving this issue, the issue of verification, I've gone into some depth about it. All I can say that the report was even more emphatic. This is a report that was done by IBC itself in the Okoa Kenya initiative, was even more emphatic on the process of verification, which must entail ascertainment that the status of the supporters as voters and of the authenticity of the signatures as theirs. I agree entirely with the sentiments of the judges, safe to say that the learned judges were perhaps too magnanimous in having been merely startled by IBC's flip-flopping on this rather straightforward matter of what it means to verify. I should think that such shifting of goalposts probably smacked of candor economy, calling for stern rebuke. It is a matter of utmost importance that all persons and institutions that appear before court be careful to be entirely forthright. Any other contrary stance brings the administration of justice to disrepute and must not be condoned or normalized. And therefore it boggles the mind that with regard to the BBI proposed amendments, IBC sees its role as different from what it stated with regard to the Okoa Kenya initiative. In sum, there does exist, with regard to the counterpart electoral processes, full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IBC lacked the requisite legal and regulatory framework in the specific issues of signature verification, and that the stopgap administrative procedures were invalid, were unassailable, and I would not interfere with them. On IBC quorum, I think a lot has been said. I am in total agreement with my brother, Justice Gatembu, when he came to the conclusion that the quorum of IBC cannot be 3. The quorum of IBC must be 5. To my mind, such a vital role done by IBC requires the full complement of IBC with all hands on deck. It is, to me, another instance of officials' failure on the IBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear a brave face and state in legal proceedings no less that it's doing just fine. A more honorable stance would have been for the IBC and the Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted and IBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, I would therefore agree with and affirm the landed judges holding that all the decisions made by IBC in relation to the proposed constitutional amendments via the BBI amendment bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IBC had managed to register some 108,000 more voters up to the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say, and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden because it is the IBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been an unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the Constitution, it is this very segment of the citizenry, the very youngest of adults, who have the greatest stake in the matter, and everything should be done to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Curricular Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. But first of all, the argument was made that we judges, the judges should not have told the IBC how to go about it because that is trying to control them. But I suggest that I do not understand independence of commissions to mean that they are anyway beyond being told by the courts what the law is. Now, if I may pause here for a moment, it becomes clear that some amendments to the Constitution do not require the involvement of the people generally at a referendum. And one of the problems of the IBC bill is that it contains both matters that require a referendum and others that do not. It contains multiple and altogether way too many proposed amendments, some of which would require a referendum while others do not. The confusion becomes intolerable in that a bill is prepared containing provisions that from their different proposed impacts requires two different tracks for enactment. Indeed, because of the numerosity of the questions, I think I have said that I do not for a moment think that it was ever the intention of the people that amendments to the Constitution should be the normal done thing whenever we feel the urge. It should come rarely, and even then when compelled by the greatest necessity. And for that reason, an amendment should come singly, once, rarely. If for any reason, and I cannot readily conceive of any, amendments must be brought other than singly, the original intent must be maintained by having each amendment presented separately and distinctly to be voted upon independently. That way, the choice presented to the people is not a binary one, and the people do not have to feel ramroded into choosing what they do not like alongside what they like, or vice versa. That Hobson's choice may perhaps be avoided by way of a multi-option referendum, but I will refrain from making any conclusive findings on it in the absence of a referendum act, the desirability of which I have already addressed under the rubric of legal and regulatory framework. I have taken the view that whereas Section 49 of the Elections Act does envision multi-question referendum, I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single amendment at a referendum for the people to either approve or reject. On the whole, therefore, I do find and hold that the learned judges were right in holding that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency apportionment and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise undergirded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IIBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2007 post-election debacle. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court's reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus Republic. It resonates with what I stated earlier when treating of the basic structure doctrine that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and present danger of violation or contravention of rights or an unlawful tinkering with or alteration of the Constitution's basic structure, such as portended by some of the provisions of the BBI Amendment Bill. The courts, when moved, must take defensive action in aid of the Constitution, even by making a preemptive strike that ensures the threatened unconstitutional amendments do not see the light of day. I have again referred to Mr. Karori's arguments in which he talks about the difference between the power of IBC over wards and over constituencies, which I agree with, but a careful reading of the judgment does not suggest to me that the learned judges held that the number of constituencies cannot be altered. I think they stated the opposite, and quite emphatically and unambiguously so, which again I have quoted them. What the learned judges did hold was that it was impermissible for the BBI Amendment Bill to directly allocate and apportion the 70 extra constituencies it created without the delimitation exercise that is commanded and provided for in detail to be undertaken by IBC in Article 89, which lists and Article 88.4, which lists the delimitation of constituencies and wards as one of the particular, and I dare say, exclusive responsibilities of IBC. To my mind, the protective role of independence commissions over the sovereignty of the people is of critical, over the delegation of the sovereignty of the people is critical and vital importance, and can only be attained by a jealous and uncompromising assertion, exercise, and defense of their independence. Independent commissions are charged with the duty of vigilantly and keenly ensuring that the state organs to which sovereign power is delegated maintain the stance of delegates accountable to their principles, and remain always the servants of the people. And therein lies the absolute necessity of the independence of those commissions being kept firm and inviolate. I would thus hold that seeing how critical the independence of independent commissions is to the sovereignty of the people, it has to be part of the basic structure of the Constitution, which is given express amplitude by entrenchment. Having taken this view, it should be obvious that I find the provisions of the BBI Amendment Bill to be an unconstitutional attack on the independence of the IBC, and materially seek to alter by the operation of various of its provisions the limitation scheme set out in Article 891 of the Constitution. It effectively attempts to repeal that provision without saying so by stealth and subterfuge. Now, it is a statement to the thoroughness of forensic analysis and intellectual engagement the learned judges brought into this aspect of the case, as indeed the entire case, that they proceeded to expound in some detail on each of the 6 reasons or markers of unconstitutionality that they identified in the BBI bill. I'm not to go into them. As I am myself fully satisfied with the accuracy and logical legal foundations of those reasons, I do not consider necessary to rehash them. The conclusion is inescapable that being so violative of the Constitution, the provisions of the BBI Amendment Bill were benighted and ill-fated at inception and had to be struck down as null and void. As to the cross appeals, I am in full agreement that both of them should fail, and that's my position. And so, finally, in conclusion, I would express my deep gratitude to all counsel and parties who appeared before us. The depth and extent of learning that went into the preparation of these appeals and cross appeals by both sides of the divide was truly impressive. The authorities were numerous and the workload quite daunting, and I must commend the industry and commitment on display before us. The erudite submissions made passionately and with persuasive force exemplify the importance of oral advocacy at the bar by both seasoned seniors and talented young legal eagles. The latter exemplify Chinua Achebe's quip in Things Fall Apart that when a child washes his hands, he gets to eat with kings. These young lawyers will soar to great heights, and should they maintain the discipline, hard work, courtesy, and professionalism that was in prodigious display before us. There is reason for optimism that the future of the profession is safe despite present troubles. As the cases, textbooks, articles, commentaries, and other authorities were in their scores, running into hundreds, nay, thousands of pages, it was not possible to refer to each and every one of them, just as it was not practical to quote verbatim all the submissions made before us for days, not to mention the hundreds of pages of the same in writing. My not having referred to any of them is no indication of their lack or worth or importance, but merely the function of limited space and time. In the end, I trust that we have all kept the Constitution safe and secure on this occasion, and may it always remain so. Thank you.
Well, thank you, my brother Justice Kiage. It is now about 10 minutes to 5, so we'll take 10 minutes health break, then come and finalize the remaining judgments.